this.
Oh, do we want to record it?
It's just pause the recording.
Oh,
And Deborah's calling me now because she can't. Hold on, just 1 second.
okay.
How's that?
We don't see anything yet.
No? Okay, hold on.
Perfect. Oh, not yet.
So yeah, presenter view again.
Yeah.
There you go.
There we
Perfect.
go.
Perfect.
That's better.
Those your birds, Sean?
They are. They're two little finches right behind me, and they're quite chatty.
I hear them.
They're happy.
That's good.
Yeah. The other ones are still asleep. Right? If I uncover those during the presentation, they're going to want to be part of it, and that's not good.
That's right. Lauren, I thought you said there were people in the waiting room, but you weren't going to let them in yet.
That was actually all of us.
Oh, all those people who signed up, where are they?
I'm not sure. And now because my slide is open.
Oh, I see 7
can't-
people now on the list.
Oh, good. To everyone who's joined us, please just give us a few moments while we wait for a few more people to join us before we start our presentation. And welcome. All right, everyone. There may be some late joiners to the webinar, but we will move on. Please just note that this is being recorded for all of our attendees. You are already on mute, but please stay on mute. You'll notice at the bottom of your screen that you do have a question and answer tab. What we're going to do is after each presenter gives their presentation, if you do have questions for that particular presenter, please put all of your questions in the question and answer box, and they will be happy to answer them after their presentation. I'm going to pass it along to Anita, who's our fundraising coordinator, who put this lovely webinar together, and she will introduce our presenters today. I'm going to stop sharing my screen, and I'm going to pass it over to Anita. There you go, Anita. It's all yours.
Thank you very much. Just give me 1 sec. Looking for my, I think I'm just gonna have to, just give me 1 sec. I just need to get my my PowerPoint up. Oh, sorry about that, you guys. just gonna get. Okay. Can everybody see that?
Oh, you have to share your screen again.
Okie dokie. Share the screen. Share. Okay.
There we go.
There we
There we
go.
go.
Okay, everybody. So sorry about that. My name is Anita Samet. I am the Fund Development Coordinator for CIPO, and we are really happy that you're here with us this morning. This is the very first legacy workshop that we as an organization have put on. And we're very, very lucky to have 3 wonderful speakers with us, all who are specialists and experts in their own field. And we hope you get lots of information from them and ask all your questions when each one is done. I just want to quickly introduce everybody. So we're very lucky to have Sean Jamieson with us. Sean is a financial planner who's been a financial planner for over 20 years. And he's a great guy. He will help you figure out everything that you need to know about leaving a gift to a charity of your choice. Sean works 1 million hours a week, I'm sure. And but he also does fun things in his spare time with his wife. He's a bird lover and a penguin lover and gets involved in community. And we thank him very much for being here. The next person we get to listen to is Deborah. Deborah Charles is a lawyer. We are so grateful that she's with us. She is located in Ladner, and she is the person you should talk to when it comes to creating a will and making your plans for what type of charity or things you want to take care of in your, for your future. Deborah is also very involved in community, and she will help you figure out what it is that you need to know to get your documents in order. So please save your questions for her after she speaks. And last but not least is Kelsey. Kelsey is a palliative care nurse consultant, and she's in Prince George. She's got many, many years of nursing experience, and she will be the person that you can talk to and ask questions to when it comes to taking care of your loved ones' nursing or medical needs and palliative care needs as we get older. So I want to again say thank you to everybody. Everybody's new to our legacy workshop. And now I'm going to hand it over to Sean, who's going to tell us all the great things that we need to know about estate planning and financial planning. Okie dokie. So here you go, Sean.
Wonderful. Thank you, Anita.
Make the host.
All right. Thanks everybody for attending, and I look forward to sharing a little bit about planned giving strategies. So we are going to look at different ways to give to charities. So let me just work through the screens here. So I think we can decide right now that we've all decided we're all here because we're interested in leaving a legacy, leaving something to a charity. And there's lots of ways to do that. And some of them involve your estate planning aspect of your financial life, and some of it is other aspects of it. The great part is you don't have to wait until the very end to make those decisions or to have decided to leave something. You can do it now, and there's some great benefits now to doing that. You don't have to wait till it's an estate. So we'll go through that as we go through my slides. So first thing you want to do is take an inventory of your assets. And a lot of people, when they think of donating, they say, well, we don't have much cash. We can't really donate anything. But there's a lot more than that when it comes to leaving something for a charity. So some people have been accumulating a nice stock portfolio, or maybe they were gifted one from a previous generation and they're still holding those stocks. So that's a piece of inventory you want to hang on to for this exercise. Life insurance policies, whether it's term or permanent life insurance, those can be certainly a very effective use of leaving an asset to charity. Another one is your valuable collections. A lot of people have been very passionately collecting or have an inherited collection of many wonderful things like art, limited edition art, original art, old coins, collectibles, and I mean, just a million possible things people collect. So that is certainly something to add to the inventory list. Next to that is things like mutual funds and managed investment portfolios and wrap accounts, things like that. And then the last thing we'll talk about today is property. So houses, land, things like that. So, and understand that this is not by any means a complete list of asset inventory, but it's the ones that most often come to discussion when we sit down with our clients. And there's certainly many more that that could come up there, but you know, this gets us started. So some assets can pass through a will and have a named beneficiary, like a charity, in the will, and others can pass outside of the will. And it's important that you actually have planned this in advance so you can properly orchestrate how this flows. And so having an estate and a financial plan before you begin is vital. And there are very significant tax implications that also play a very important role as you decide which types of assets you want to pass to charity. And we'll begin to discuss some of those in our short little time together here today. So gifts of cash. So one thing about cash, it does not trigger capital gains. Cash is typically just already post-tax capital. So if you have money in a savings or checking account and you gift that, it doesn't trigger capital gains. The nice thing too is it also can be used immediately by the charity. It doesn't have to be converted to cash from, say, art or from a stock portfolio or land. And the charities really appreciate that. Charity will issue a tax receipt for the cash equaling the cash. So if you donate $10,000, you're going to get a tax receipt for $10,000. In BC, the tax credit ranges from 20% of each dollar donated up to 43, almost 44%. And the difference there is really the first $200 that you donate to charity within a tax year gets you about a 20% tax credit. And then every dollar after that gets you a 43% tax credit. So after $200, the tax credits really start to add up quite nicely. Okay, the gifts of stocks, securities, we call them. So if you have shares in Coca-Cola or Toronto Dominion Bank or all these different types of stocks that people can own, and you haven't cashed them in yet, they have a market value. And the charity, if you donate a stock, you can donate it, what we call it, in kind. So you're not selling the stock and giving the charity the money. You're actually giving them the stock directly, and there's a specific way it needs to be done so that that you are not having to trigger a capital gain or a capital loss before you then donate this stock to a charity. The charity then receives the stock at its fair market value. So let's say it's a $10,000 worth of stock. The charity receives it and will give you a tax receipt for $10,000. Now, let's say that those stocks were bought a long time ago and the original cost was $2,000. That means the charity is going to get a $10,000 donation, and you save having to pay capital gains on $8,000 worth of capital gains, which is a nice little way to pass on a potential tax that you would have to pay directly to a charity, which won't have to pay that tax when they cash it in. So again, if you're leaving stocks, you need to carefully plan that so that it's going in a tax preferred way to your estate. The next one, and this one can certainly get quite complex, but very, very lucrative to both you and the charities, and that's the gifting of life insurance. So the great thing is it's a tax-free proceed to a charity. So if you've left an amount to charity in your life insurance, it doesn't pass through your estate, it doesn't pass through probate, and it is not taxed. So it can go directly to charity. They receive cash, and of course they would issue a receipt based on that cash quite quickly, and they can make use of that money without too long of a wait. Like I mentioned, it bypasses the estate and probate fees in most cases. Charity can be simply named as beneficiary of an entire policy, or even just one of many beneficiaries in a policy. So perhaps I've got one large policy. I want to name perhaps my 2 children as part beneficiary and a charity as part beneficiary. You can do it that way. You can also, excuse me, you can also name the policy as, you can name the charity as policy owner, and it has different tax implications that would benefit you now while you're living, as well as when that money eventually flows to the charity. The charity issues a receipt based on the amount received. So that may change depending on the types of policies that actually grow over time. The amount that eventually goes to charity could be quite sizable, and certainly larger than it would be now. And the tax receipt would be issued based on the value they receive at that time. So again, it can be quite substantial. Many philanthropists have donated a very large policy to a charity that ended up being in the tens and hundreds of millions of dollars, and left quite a legacy for themselves. So there's definitely lots of strategies that we want to explore with using life insurance, both while you're alive and living, as well as you pass it through an estate. So quite an involved one, and certainly you want to discuss this with your financial professional before you jump in and start making some changes here. All right, the next one is the gifts of things like art and coins and collectibles. And there's lots of curves and wrinkles and complications with this one. And I say that in advance, as again, you want to be deliberate and specific about how you use this particular donation. Things like art, for example, needs to be professionally appraised in order for it to count as a donation. Any piece appraised over $1,000 anyway would have to have a professional appraisal that went with it. Things like art in particular is determined by where was the source of that art? Was it inheritance? Did you purchase it? Are you the artist yourself donating it? Or are you part of the artist's family? That changes the way a donation is made. Are you a collector or a dealer? Again, each of those sources change how that donation can be made. Art donation can be used, actually most collectibles can be used to offset 100% of the net income instead of 75, if donated specifically to a gallery, and or if it's a culturally sensitive piece of art, it also has special privilege. So when you're going through your collectibles art coin collection and saying, okay, I'd like to use this as part of my donation, again, you'll definitely want to seek professional guidance from a financial advisor and lawyer to say, okay, how do I arrange this properly based on these types of parameters that we're just talking about? The last thing, and quite important, is you want to predetermine if the charity is willing to accept this type of donation. Not all charities are equipped. Some of them are quite small and don't have a lot of sort of support or people involved, and may not want to accept a coin collection or art because they don't know how, or don't have the expertise to receive it and then turn that into something that they can use. So before you name the charity, please talk to them first and say, look, this is what I intend to do. Is that something that you guys will accept? So you may have to shift who gets what if certain charities don't don't have the capacity. So qualified donees. So registered charities are places that you can certainly donate things to. Registered Canadian Amateur Athletic Associations, National Art Services, listed housing corporations in Canada, things like Canada, BC and Canada Housing, senior centers, government supplied ones, municipalities. Again, if you're donating sensitive cultural artifacts, things like that, municipalities, different levels of government can take those and issue charity receipts. The United Nations, universities can be doing that, and of course the federal government is also something that can receive things like art and culturally sensitive artifacts. All right, the next one is the gifts of mutual funds or investment portfolios or wrap accounts or things like that. There's all different types of words that we can use for things like mutual funds, ETFs, exchange traded funds, things like that, all qualify under the same umbrella as this one. And similar to the donation of stocks and securities, you can actually give the mutual funds without having to sell them first. So the charity can again receive the fair market value of the mutual fund units, regardless of what you paid for them, and would issue a receipt based on the fair market value. Then again, you as the donator avoids paying the capital gains if there's any. So again, an advantage for you as the donator, and the charity is also gaining an advantage of receiving the full fair market value and not likely having to pay any taxes on it when they sell it. So again, the important thing to stress here is that you want to carefully orchestrate from your inventory what it is you're looking to donate, and have someone help you plan that. Next is the gift of property or land, housing as well, houses. This also can be done to avoid paying the capital gains tax on property. I'll give you a quick example. We had a client donate their summer cabin up at Shuswap Lake, and they had bought the cabin and the land back in the 50s, and they paid $2,500 for the land, and then they built the cabin themselves. So there was, other than just some lumber, there was not really any big cost to the cabin. But the cabin is now worth $1.2 million, and it's not their principal residence. So if they sold that, they would actually have a capital gain of almost $1.2 million, and almost $300,000 in income tax would have to be paid, which is a lot of income tax. So we have set it up so that they would donate that property to the charity that they've chosen, and they would not have to pay income tax because the charity would receive the value, the fair market value, as a donation. Now, again, like many things, you don't have to wait till there's an estate to settle. You can also do this while you're still living. And the donor can receive significant cash by the way of a large cash refund. So if you donated $1 million piece of property, you're going to get a $430,000 tax credit, which you may not even be able to use all of it. But again, consult a tax professional, consult a lawyer, consult your financial planner before actually proceeding with a land donation, because it's quite complicated and you want to do it correctly. And again, culturally or environmentally sensitive land is treated differently. We won't go into the details on that in this presentation, but definitely you want to be consulting professionals before you donate that kind of land to a charity. And back to the donation of art, you also want to check with the charity again, even more importantly with this one, to see if they're willing to accept land, because you don't want to be having the charity incur a huge perhaps cost to then own and hold that land while they find a way to deal with it. So again, making sure that they're saying, yes, we're equipped to take this type of donation. You want to be doing that certainly before you proceed. Okay, so some general things to consider, just generally in making donations to charity or leaving a legacy in your estate. Like I said before, and I'll continue to say again, you want to be speaking with financial and legal professionals to avoid very costly mistakes. Charitable donation receipts can be carried forward 5 years, and unclaimed receipts from the previous 5 years, which means you're using carry forward receipts from before. Typically, you can be using charitable donation receipts to offset 75% of your net taxable income in any given tax year, and 100% of your net taxable income in the year of death. So when you're leaving assets in an estate, it's quite powerful in terms of offsetting taxation in that year. A proper legal will is probably the most important tool for estate planning, especially if you've got several assets and perhaps several people and several charities that you're wanting to recognize in that estate. Having just had conversations with people isn't going to hold it. You need a legal will prepared by a professional to make sure that it's done correctly and cannot be torn apart by someone who's going to challenge it. So somebody like Deborah, who is very skilled at doing this, you definitely want people like that in your corner, being able to orchestrate your plans properly and according to your wishes. So that is a whirlwind tour of kind of the shopping list of different assets and different things in your investment inventory that you could consider leaving to a charity. And I know for many clients that I've worked with, it has really opened up their eyes wide open to many things they didn't think were even items they could leave to a charity. And charities have benefited greatly by them learning that there are other things they didn't know they owned as an asset that they could leave. And so that is something for all of you to consider, that that leaving things like collections or land that perhaps you didn't even know what to do with may just be a win-win for everyone. As you see here, you have my phone number, you have my email, and if you have any follow-up questions that come in after our presentation today and you didn't ask them in the question and answer, please feel free to drop me a note and just ask your questions. I'm glad to help in any way I can. So thank you very much for tuning into my little part here. I'm now going to hand this over to Deborah Charles, who is going to continue. Just a moment here while I do that. There we are. Actually, just a second, I'm going to unshare. No, I've done that. And Deborah, you are now host.
Thank you. There you go. You should be able to see my screen.
Yeah.
Perfect. Okay. Hi, everybody. My name is Deborah Charles. I just want to start by acknowledging that I'm attending from the traditional territory of the Tsawwassen and Musqueam First Nations and of all the Hul'qumi'num speaking people. Today, I'm going to speak to you about the basics of estate planning. I've had my intro, so I'm going to step right into it. I'm going to be about 20 minutes, but please feel free to put questions in the chat while I'm talking, and I'd be happy to answer them afterwards. So we're going to cover what is estate planning, basic estate planning documents to know about, key decisions and why to make them now, probate and taxes, and planning for incapacity. Sean has covered so much about giving to charities very succinctly and clearly. So thank you, Sean. That was great. And I will talk a lot about representation agreements because Kelsey is going to cover that after me. But I will just say up front that what I share today is general information. Don't take it as legal advice and act on it. Work with a professional. There are exceptions, laws change, but I hope that this is helpful to give you a start. So what is estate planning? It's mapping out how you want your personal and financial affairs to be handled in the case of death or incapacity and creating the legal documents necessary to do so. I start with that definition because we all think about planning for death, but at the same time, when you work with a lawyer to do your estate planning or financial advisor, you're also planning for incapacity. You know, any of us can get in a car accident or have an illness strike at any time, and it's really important to do that planning at the same time so that that's done. So the first document we all know about is the will. It's the legal document in which, in its most basic form, you appoint an executor, you appoint guardians of your minor children, and you direct how your property will be dispersed after you die. There are all kinds of other details you can include in your will. You can specify, oh, I'm gifting this vacation property to this child. Who's going to pay the balance on the mortgage? Is it them or is it my estate? You can specify who's responsible for certain taxes. If you have minor children, maybe you want them and their guardians to be able to live in your home. So you need to specify that and specify who's going to pay which expenses. Maybe you want to pass your vacation property onto one of your children or multiple children. Maybe not a good idea to have them have to share it in joint tenancy, but you know, once you've thought through the pros and cons, you specify these things in your will. And then also setting up trusts, which we will talk more about, because until they're explained, it's not obvious how they work. But I'd like to start by talking about beneficiary designations, because they're a really important part. Like Sean said, not everything flows through your will. And so beneficiary designations are one of those things. If you've ever got life insurance or RRSPs, RIPs, TFSAs, you've probably seen a form that looks a little bit like this, and you've been asked to write down the name of a beneficiary. And you probably were not given advice about the consequences of doing so. So I'd like to say up front, two things. First of all, find out who your beneficiaries are that are listed from all those old forms. Contact your insurance brokers, your bank, your financial advisors, find out who's listed. And secondly, take caution. There are some situations where it's great. You might have up-to-date beneficiary designations to your first spouse and everything will go smoothly. And there are a lot of situations that will cause a lot of trouble. So why do people do it? People designate beneficiaries on life insurance, RRSPs, etc., to avoid probate, usually. So probate is that court process that happens after we die, where your executor takes your will to court and says, and then the court basically gives an order authenticating it, saying this is a valid will, this is Deborah's last will, and so is authorized to be the sole executor, and therefore the land title office or the banks or different authorities can feel comfortable transferring that money to that executor. So that's a process that our will goes through, and everything that passes through the will, there's probate fees on that. So of course, people like to avoid fees and they like to avoid the delay of probate, and that all makes sense. But at the same time, probate fees are very low and it's not always worth the consequences. So some of the things I would watch out for are, first of all, forgetting to update your beneficiary designations. Check them out, put it in your calendar, check it out every few years. There was a case in CBC, a story last year, where this couple had their shared retirement savings in his RRSP, and he was diagnosed with terminal cancer. They took all the steps they thought they needed to take. They went to the lawyer. He said, I'm leaving everything to my spouse. She has to look after my 13-year-old daughter. He thought it was all taken care of. And then after he passed away, his wife found out that all $685,000 was actually designated to his mother, because he had done the designation before they got married and he'd never updated it. The law didn't change the situation when they got married. And on top of the fact that that money was going to the mother, the tax consequence fell on the estate, and she was the residual beneficiary of the estate. So, you know, $300,000+ in taxes as well fell then on her. So, you know, look at updating them. Secondly, don't name your minor children on these. There's a box for trustees, but if you know, if that trustee can't act, the public guardian and trustee would be managing the money. And because this is just a one-liner, there's no place for you to put the trust terms. Like, I would like this paid out gradually to my children, to get a little bit when they're 25 and a little bit when they're 30, and the kinds of things that you can specify in your will. So if you name minor children on these designations, it's managed by a government entity, and then the children get all of it when they turn 19, which probably won't serve them very well into life to not have that money paid out gradually. So the other thing to watch out for is talking to your advisors and understanding who pays the taxes. On death, your RRSPs are taxed as though you received all of them. So depending on your marginal tax rate, a $100,000 RRSP might incur $53,000 in taxes unless that is being rolled over to your spouse. So if that's going to come out of your estate, you need to understand that so that you don't think, oh, I'll leave my RRSPs to this one child and the residue of my estate to the other, and it's going to be even, because you might find that you're actually leaving very unequal amounts, or even disinheriting a child or somebody. So be careful of that. Be very careful of naming multiple people on these, because if one of them predeceases, the rest goes to the other ones. And so you might disinherit a branch of your family, some of your grandchildren, that kind of thing. And be careful with leaving to adults other than your spouse for all kinds of reasons. Make sure that you document carefully what your intentions are. And also, if you're in a blended family, you have kids from a first marriage and you're the second spouse, be careful again, because you might set up trusts in your will, and then this would pass directly to that second spouse. It wouldn't go through your will, it wouldn't be in the trusts, and there's a good chance your children would never inherit that after your spouse passes away. So lots of areas for caution. I would have a look at your beneficiary designations, and you can always just get help. You don't have to understand everything I've just laid out, but you can always just get help with it. The key thing to remember is just to exercise some caution. And secondly, as I believe Sean mentioned, you can designate charities as well. And so that is also something to look at. I'm going to quickly talk about what is a trust. It's basically a relationship or an arrangement between three people. So I might say in my will, I am leaving everything that's left over in trust to my child, and I'm going to name my sister as trustee. And so therefore my sister would hold, my money and my house and everything in legal title in her name, but it's for the benefit of my son. So she manages, administers, distributes, but it all has to be used for my son. So that's sort of the basics of what a trust is. It's moved into the legal title of somebody else, but for the benefit of a third person. They can be set up while you're alive. That's generally where there is a bit more wealth involved. And they can be set up in your will. So we'll talk a bit more about this on the next slide. We think of trusts as something out there that don't involve us, but there's actually a lot of very useful situations to set up trusts in your will. So we'll look at that. So why plan for death? First of all, to name a guardian. If you don't write a will and you don't name a guardian, but you have minor children, the ministry takes over guardianship of your children, and your family members then have to go to court and argue for that authority to look after your children. That would create a lot of expense, a lot of delay, uncertainty, stress, maybe even conflict. And even if choosing a guardian is a very difficult thing to do, I would suggest that it's better to have chosen one and have some certainty for your children in case something happens to you, so that there's not a long period of uncertainty around who the parents would be and who's allowed to look after the child in the meantime. Secondly, we plan for death so that we can provide for our loved ones and charities we care about. So in your will, you choose where your property goes. If you don't choose in advance, the law has decided that for you. There's a statute laying it all out. And so you might think, well, I have a spouse or a common law partner. Of course, everything would go to them. But that's not the case. They get a preferential share and they split the rest with your children. And so your spouse might not be properly taken care of. There are better alternatives. And if you don't have a spouse or children, it could go to some distant uncle or something that may not have been your choice. And if you have none of those, it basically goes to the government. So far better to have chosen where your money goes, provide for loved ones, give to charities you care about, and have that be your legacy. So thirdly, we plan now to choose our executor and trustee. The executor has a very big job. They notify all the beneficiaries, they work with the lawyer to get probate, they file taxes, pay debts, insure your properties, sell assets, distribute the money. There's a lot more in that list. But basically, if you don't name an executor up front and an alternative executor in case your first can't act, maybe even a third alternative, there's nobody in the early days with the authority to make decisions, deal with your assets, insure your properties. And then again, your family members have to apply to court for the right to have that authority as an administrator, which is extra conflict and extra stress at an already very difficult time. So better to have chosen somebody that you can really trust and to save your family that extra stress. And the same goes for the trustee. You know, the trustee is the person who's going to manage the money for your minor children or beneficiaries with disabilities or other trusts you might set up. And so you really want somebody that you trust, that's impartial, and that's something, you know, if you're not sure who to pick, that you can talk about when you're drafting this with your lawyer. So fourth, we plan now to set up trusts where they are appropriate. So I've talked about setting them up for minor children so that the public guardian and trustee doesn't manage that money and your kids don't get it all when they're 19. You also want to set up trusts if you have any beneficiaries with a disability. First of all, it might be that they're unable to manage that money and you want somebody you trust managing it rather than a government body, and rather than somebody being appointed by the court who may not have been your choice. But secondly, beneficiaries that rely on provincial disability benefits might lose entitlement to those benefits if they receive all of your money outright, or even a chunk of your money outright through, you know, either a will that's drafted without a trust or just through the statute because you haven't written a will. So that can turn out to really be a problem for those people. So if you set up a trust, they can also still be entitled to those disability benefits. Thirdly, might be useful if you have a blended family. This allows you to, for example, say, okay, my second spouse can use all of my assets while they're alive. This is a way to support your spouse while they're alive and make sure they can take care of yourself. But when my spouse is gone, that capital will get transferred to my children. So there's also a wealth transfer component. So there's a way to make sure that your children don't get disinherited, because that can very easily happen. You think it's okay, we've both written our wills and we're both leaving everything to both of our children. But in fact, very often one of the spouses might either get remarried or end up leaving everything to their kids, or, you know, gifting it all away. And your children from your first marriage can be disinherited. So trusts are a good idea here, or other options for blended families. Trusts are not the only option. But something to think about is how to serve your second spouse and your children. And the final sort of useful space for a trust in a will I'll mention is for other adult children. So they don't have to be minors. You might have adult children who you're worried about their marriage or addictions or a business, or maybe there's just tax saving opportunities for them, and you might want to set up a trust for them, or just wait until they're more able to manage the money when they're older. So fifth, we plan for death now to minimize taxes. Taxes can really add up to a lot. You end up, you know, when you die, you have the biggest tax bill of your life, and you can end up in a 53% marginal tax rate. And, you know, there are sometimes easy ways to say, okay, well, this one should go here, or I should name a successor holder on this, or there are some ways that sometimes we can save on taxes and avoid unnecessary taxes so that your loved ones and charities get more. And then finally, just avoiding issues. So we plan now to avoid unintentionally disinheriting somebody, or leaving kids unequal amounts, or not documenting something properly so that one child says, no, I was a joint tenant on the house because it was a gift to me. And the other one says, no, you were holding that to share with the rest of us as part of the estate. And now you have two children in court spending tens or hundreds of thousands of dollars and probably never speaking again, which is really not what you want. So you want to plan properly now. Move this along. It will move along eventually, but it's really, there we are. So you want to think about your plan. Not everything goes through the will, as we've said, and it's a lot for somebody to figure out. So it's really helpful to speak to a professional who specializes in estate planning. Some assets will go through your will, and that's the best place for them. Others might, you might designate a beneficiary. You might have a joint tenant on your house, once considering who they are, what your goals are, all the risks. There might be inter vivos trusts, so trusts while you're alive that you'd want to set up if there's significant wealth involved. And you might, even if you have a corporation, have a second will if there's a lot of value in your corporation. But you don't have to understand all of it. You just have to know there are options and talk to somebody about the best way to set up your assets. So why plan for incapacity? We've talked about why plan for death now. We plan for incapacity now so that we're naming people that we trust to help us in the event of compromised mental capacity. It's never too early to plan. We're all susceptible to a head injury in a car accident or some other medical issue leading to a decline in our mental capacity. But it is too late to plan if something happens and you haven't signed those documents and you don't have the capacity to do so anymore. So if you have somebody to sign, appoint who can step in and do your banking or run your business or insure your property, pay your rent, keep things going, that's really good. So the two main documents we use for that are, first of all, the enduring power of attorney. It allows you to name somebody to make financial and legal decisions on your behalf. There are precedents online that people use. I recommend working this through with a professional. There are all kinds of powers that a basic precedent doesn't include. They would just be the default powers in the law, in the statute. So you want to think about what extra powers your attorney might need based on your situation. You want to think about who you're appointing. If you want to appoint multiple children, what are the details of that? Do they both have to sign? Can either sign? When do you want it to come into effect? What if something happens to one of them? So some really important things to think about there, especially if you have, if you're in a blended family or you have a corporation or, other complicating factors. And a representation agreement is for healthcare decisions, and I'm going to leave that to Kelsey. So I'm going to move right along. And so when you put it all together, we have, you don't need to read all the text on this, but this is basically a timeline. So we have now, where we're doing our planning, you can have your enduring power of attorney come into effect now, so that if you're out of the country, your attorney can sign a contract for you or something like that, with your permission, and there are safeguards, because it's a very powerful document. So then we move along to, okay, we've lost capacity at some point. If you have a properly drafted enduring power of attorney, that document will continue to be in effect past incapacity, and your representation agreement or other healthcare planning documents come into effect then as well. And then when we die, those documents stop being in effect, and our will and other estate planning documents come into effect. So that's sort of the big picture of what your lawyer, financial planner together are able to put together for you. So there's a lot of special considerations where you really need to make sure that you're not just, there's a lot to think about and plan before you just get to the drafting stage and think, oh, my friend sent me this precedent, I'll just put my, the names in. There are a lot of special considerations if you have property in another province or country, disabled beneficiaries, US connections, blended family, business. If you're looking at doing an unequal distribution, if you have minor children, your previous agreements with a spouse, creditors, if you have real property, RESPs, there's all kinds of things that require special consideration by talking to a professional. And that's it. I welcome your questions either today or getting in touch with me at this phone number or email. Thank you so much for your time. gonna have a look up here. I think I see a couple questions. Okay, no, just comments. Well, I welcome your questions after all the presentations are done, and I'm going to pass it on to Kelsey now. Thanks very much.
Unmute. That's key. Okay, can you guys all see my screen? Okay, hi everybody. I'm Kelsey, and I'm a palliative care nurse consultant. I work here in Prince George, and we're going to talk about advanced care planning. So I just want to start with, I have nothing to disclose. And we're going to talk about what advanced care planning even is. Maybe you guys have heard of it. I was not familiar with it before I worked in this role. We're going to talk about who would make decisions for you if you're unable to make your own decisions. And you don't have to worry too much about remembering all of the terminology and rules and things today, because we'll finish with resources so that you guys know where to go to get more answers and to find all this information that I'm talking about in my presentation. So there's a lot of writing here on this slide, but just bear with me. So advanced care planning, it's a way for you and your family to prepare to make decisions about your future healthcare. So it involves reflecting on and sharing your values, beliefs, and wishes regarding healthcare and personal care with those close to you and your healthcare team. So this information is used during conversations with healthcare providers about the treatments and care you receive to help make sure that you get the care that's right for you. So it may consist of a representation agreement that Deborah was just mentioning. I also saw in her slides advanced directives. So we'll talk about what those things mean in terms of healthcare. It can also just be written or verbal expression of wishes. So advanced care planning can be quite informal, or it can be like a legally binding document. So I just want to emphasize that it is a process. So it's a series of conversations. It happens over time. It's not just like one thing that you sit down and do and then it's done. And the purpose of doing it is to communicate your wishes and preferences and what gives your life meaning. And secondly, to identify who your decision maker will be for healthcare. It's important because it helps you to explore your values, beliefs, and wishes. It helps you understand who's even going to be making decisions for you. And it helps to prepare you to make difficult healthcare decisions. So really just getting the care that's right for you. Really, advanced care planning helps ensure that your wishes are honored, but it's also really a gift to your loved ones and your family. So when we ask ourselves, what is a good death? The answer varies greatly between individuals, and ultimately, it's generally whatever the dying person says it is. But the experience of death is really felt by and really carried by whoever is present at death, which is often our loved ones. So when family is left with an advanced care plan and a very clear knowledge of what the dying person would want at end of life, it allows the family to just be present with the dying person at end of life, rather than worry about what decisions they've made for their loved ones and whether those are the right decisions and the ones that their loved one would have wanted. So as much as advanced care planning is for you and to make sure your wishes are honored, it is also a big gift to your loved ones or whoever will end up making your decisions for you. So I just have a short video here for you guys to watch. It is a little bit emotional, but it does a really great job at showing advanced care planning in action.
My name is Diana, and we and I are husband and wife.
My name is Anita, and John is my dad. My name's John. I'm Quivy's husband.
So Roy gets to go on a trip of a lifetime. Where does he want to go?
I'd say Bora Bora.
Well, I definitely want to go with Bora Bora.
What food could Anita not live without?
Probably curry.
Anything Asian?
He couldn't live without a lot of food.
And what about you? What food could you not live without?
Probably fruit in general.
Probably chocolate.
Just
What?
Anita asking me, so what's this about? I said, I don't know.
If you can think about a moment where you pushed through a hard time together, can you describe that?
At school, when she was being bullied, we had to see some counselling.
Just talking me through it and helping me get through it. Kind words and lots of hugs.
For me, it was probably the time when we were first trying to have our first child, I guess. We went through IVF and things like that. Becoming parents is something that we all hoped would come naturally, but it didn't to us initially, and we worked through that together.
Roy's hurt in a car accident. He needs a breathing tube for the rest of his life, and he'll never speak again. Would you consent to this?
Well, yeah, I would, yeah.
No, I wouldn't. Definitely not. I don't think I would want to burden anyone with that. So I'd rather not. Yeah.
Anita had 3 months to live. Treatment would give her an extra 2 months, but she would never see outside of a hospital. Would you consent to treatment?
Yes, this was a difficult one, this one. 2 months, you know, it's just 1 week, 2 months, any time.
Not at all. No.
That's unexpected.
I don't want to be kept in a hospital for forever.
John has had a massive stroke. Does he want a feeding tube to keep him alive, even though he'll never talk again?
no.
No, I don't. It's very important to me to be happy and functional in my life. No, I wouldn't want that to happen.
Roy's in the last stages of terminal cancer and his heart stopped. Does he want CPR?
Probably not. I don't think you would, no, I don't know.
So how do you both feel after answering those questions, and why?
It felt quite confronting in a way. But
You think about it and you talk about it just very lightheartedly, but I don't think anyone really puts a lot of thought and serious thought into it.
No.
Why do you think that some couples don't talk about this?
It's not a pleasant subject. I mean, nobody wants to dwell on the fact that they're going to die one day, and possibly in adverse or difficult circumstances.
So if I was to tell you that advanced care planning is essentially a conversation that helps your loved ones know what medical treatment to choose for you if you had a sudden event, what would you think about it now?
I think it's a great idea.
Yeah, absolutely.
It's important, not just for yourself, but more so for your family, I think.
Definitely have to have a bit more of a talk. And it's not just about the two of us. We
got
also
kids
have kids and all that kind of stuff, yeah. So there is a bit we need to consider, yeah, 100%.
So I watched that video like 100 times. It gets me every time. I think it does a really good job of showing that we can know someone so well. We can know their favorite foods. We can know where they'd like to go on vacation. That doesn't always mean we know what they would want at end of life. And as difficult as having the conversation can be, as difficult as it is now, if we don't have it now, it is so much harder later, not knowing and trying to make the best decision, but with all this uncertainty and all this emotion and in a time of crisis. So, who should do advanced care planning? So it's really for everyone at any stage of life. It is for any adult. You don't have to wait until you're in crisis. You don't have to wait till you have a serious illness. It's actually much easier to do it when you are healthy, when you are young, when you can make your own decisions. But if you do have a serious illness, it's even more important that you have it. If you have family that may have different views or beliefs to your own, it's also very important that you have it. And especially if you have a condition such as dementia that will lead to loss of capacity to make decisions. So it is for everybody. We want everyone to do it early, but kind of if you are unwell or have any risk factors, it's even more important. So it's never too early. I think Deborah said the same thing. It's never too early until it's too late. So a lot of people don't do things like choose a decision maker because they think, well, I have the ability to make my own decisions now. I don't need a decision maker. I don't want to give that power to someone else. But making an advance directive or making someone your decision maker doesn't actually come into effect until you lose capacity, if you even ever lose capacity. So it's the kind of thing that it's a safeguard, it's there, it may not need to be used. It doesn't hurt to have it now because it just gets harder or impossible to make it later. As I said, advanced care planning is not a one-time thing. It's something that you want to review regularly, you want to revisit it. As your health status changes, your advanced care plan may change. It's something that can change over time. It's not set in stone. So there are a lot of treatments at end of life that may or may not be applicable to you, and it can be really hard to know which treatments might be appropriate for you or what you would want. It might depend on the situation. So you may want to do some research about what options are available. But also, without kind of knowing all these medical options that might be available, a good starting place is to reflect on these three things, or at least on these first two things. So what gives your life meaning? And what do you care about in your life? And communicating this information to your decision maker will help guide them in any specific situation, know what is best for you. If you know that you have specific wishes about future healthcare or life support or life prolonging treatments, that's definitely important to let your decision maker know. But like I said, I think a lot of information can be gained by sharing those first two pieces. As we saw in the video that we just watched, some people maybe haven't had the conversation, I do or don't want a breathing tube, or I do or don't want CPR. But if you know that it is important to someone, that what gives their life meaning is going for walks or being outside, if a situation presents themselves where the outcome is that they may have more time, but that time is not leaving a hospital and it's in a hospital bed, that kind of information can really help to guide the decision making. So just to kind of give you an example. So there are 5 steps that we'd like you to think about. Think about what's right for you. Learn about the different medical procedures that may present themselves. Decide who will be your decision maker, and we're going to talk about decision makers in a second. Talk about your wishes with that decision maker, and record things. So write things down. Don't leave anything up to memory or interpretation. Try to kind of put it in concrete form. So here in BC, we use this booklet. It's called a My Voice booklet, and it's basically an advanced care planning guide. It's like a workbook. If you work through it, you will have an advanced care plan. So it has a bunch of information. We'll talk about everything that we talked about today. It has forms for designating a decision maker. That form can be made legally binding if it's signed appropriately. It also has a place for you just to record things that may give your life meaning. So it's kind of the resource that we use here in BC, and it can generally be found from your doctor's office, in the hospital, as well as online. You can fill it out or order this booklet as well, and I'll give you that resource at the end. So what happens if you don't have an advanced care plan and you haven't designated someone to be your decision maker? What happens is it goes to this thing called a hierarchy tree, and a temporary substitute decision maker is elected. This is a TSDM. And so if something happened to you where you lost capacity and we needed a decision maker, the healthcare team would make what's called a reasonable effort to contact whoever is next in line in this hierarchy tree. So usually it's the spouse. If there is no spouse, it would go to the children, adult children. It's important to know that the birth order does not matter for adult children. So if you have multiple children, it's not necessarily the oldest that will end up making the decisions. If multiple children are involved, it needs to be an agreement among all children. And so on, you would work down the list. As you can see, the further you go down the list, kind of the further removed it tends to be from, it may be more removed from you. But the healthcare team will just keep moving down the list until they find someone who can make this decision for you. We'll talk a bit about who qualifies. So in order to be a decision maker for someone, you need to be at least 19 years of age. You have to have been in contact with the adult during the last 12 months. You have to have no dispute. You have to be capable of giving, refusing, or revoking consent, and you have to be willing to comply with the duties in the Healthcare Consent Act. So that basically just means that you're going to act in the best interest of the patient, and decision-making is going to be based on how well you know them, what you think they would have wanted. So if we go back to our TSDM list, if we say can contact a child, but the child has been, let's say there's no spouse, so we go to a child, we contact a child, we reach the child, but the child has not been in contact for the last 12 years, we would have to continue down the list until we find someone that meets all of that TSDM criteria. So if you don't want to leave it up to the TSDM hierarchy tree, you can do something called a representation agreement. And so this means that you would designate a specific person who would make decisions for you if you are unable to make them for yourself. And what's important to know is that there's a few different types of representation agreements that you can make. You would want to make the Section 9. And again, this is in the My Voice booklet, but you can also get forms available online. So the Section 9 specifically allows your representative to make decisions about personal care, healthcare, and most importantly, about accepting or refusing life support and accepting or refusing life-prolonging medical interventions. So another tool that we have for decision-making is called an advance directive. And an advance directive is written instructions expressed directly to your healthcare provider or your representative if you've named one, and it identifies healthcare that you consent or refuse to. So if you have an advance directive, but you do not have a representation agreement, the healthcare team would look at the advance directive for direction rather than going to your TSDM list. So it would use your advance directive as like explicit written instructions from you, and they would follow those directions unless a situation presented itself that falls outside of the realm of the advance directive, in which case they would defer to your TSDM. The important thing to know as well is that in a representation agreement, it would take precedence over advance directive. The representation agreement, or whoever is elected as your decision maker in the representation agreement, would be following the advance directive, but they would still have a higher decision-making authority than the advance directive. So it's just one other tool to communicate your needs and your wishes for end of life. It's important to note that it is used only when you're unable to make decisions for yourself. And as I said, in the absence of a representation agreement, the TSDM may be consulted if a situation arises that is not addressed in your advance directive. So some of the resources, which I think we can get this slide maybe sent out to the participants, is Speak Up in BC. This is where you can get your My Voice booklet, or you can fill out an advanced care plan online. HealthLink BC is one of my favorite resources for exploring medical interventions. It has a decision tool, and it goes through all sorts of things that come up at end of life, like artificial feeding, artificial fluids, CPR, intubation, all sorts of things. And it talks about when those interventions are helpful and when they might actually be harmful. I think there's sometimes a misconception about the healthcare system or about medicine in general, that a lot of the things offered by medicine give us more time. And it's true, in many cases, they do give us more time. But we always want to ask, is that time meaningful? What is the chance of meaningful recovery? For example, with things like CPR and intubation, they're extremely effective for very young, healthy people. In elderly, frail populations or people with advanced illness, there is very little research to support that they would actually prolong life in a meaningful way, and instead can actually cause suffering and trauma. So we really want people to understand and make decisions that further meaningful time, not just time period. So it's always your choice, but we just want people to be informed and know what their options are, and be really active and engaged in their healthcare decision making, and not just passively kind of following along with whatever happens. So listed are some other resources: Dying with Dignity in Canada, Northern Health has their own advanced care planning information, and the BC Centre for Palliative Care is also a great resource. So I'll just finish with this little cartoon. This gentleman is trying to do some informal advanced care planning. He says, "Just so you know, I never want to live in a vegetative state dependent on some machine. If that ever happens, just unplug me, okay?" So his wife says, "No problem." So I hope that this was a good kind of intro for you guys. I know it's a lot of terms and a lot of terminology, but I guess now we can open it up to questions. I'll just pass it back to Anita, and we can go from there. So thanks everyone for your time.
Hi, everybody. Can everybody hear me? Yep. Do we have any, I don't see any questions in the question and answer box. Now would be a good time to do that. If you don't, oh, Deborah.
I just have something I'd love to add to Kelsey's presentation as well, is just, you know, the list of temporary substitute decision makers. You might be looking at it and thinking, oh, well, I'd love to appoint my spouse anyway, so why bother doing a representation agreement? And I think it's important to know that there are some limits on what that TSDM can actually refuse or give consent to, especially when it comes to end of life decisions. So if those decisions are important to you, it's especially important to actually appoint somebody in a representation agreement, because that gives them, there's less limitations on the things they actually will have a say in. So I'm sure Kelsey said it, but I just wanted to kind of put that home just in case anyone leaves thinking, I'm appointing my spouse anyway. You know, there are a lot of benefits to doing a representation agreement.
It is actually a really good point. And it's the kind of thing too, I think a lot of people look at that TSDM list and, like you say, oh, well, it's my spouse anyway, that's who I'd want. But you really have to be okay with anyone on that list, because you never know in what situation that TSDM is going to be enacted. If you have an accident when you are with your spouse, then you have to be okay with all of your children. And really the healthcare team is is doing what's called making a reasonable attempt. So it really depends on the situation. They may move down that list. You have to really be okay with anyone on it. And like you said, you can run into problems with kind of the limitations of it. So I agree. It is what we use. It's, you know, works for some people, but there is a lot of things left up in the air with that option for sure.
So I see a question in the question and answer box. It says, what if you were dealing with someone who has brain damage and too late, but living a good life now, and you are the trustee? So I'm not sure who that's directed to. Did you guys hear that?
Yeah, so is trustee kind of, so this is about the financial, it's a financial question kind of, or?
Carol, can you tell us who is you're specifically asking that question to? To you, Kelsey.
Okay, wait, let's see. I am not seeing.
Just to help you out there, Carol, in case you want to clarify your question, are you referring to, sorry, I didn't see the beginning with the situation, but the trustee is somebody who would be managing the money for somebody. We have all these different roles, right? We have the executor who's managing your estate. We have, you know, if you're gone, we have an attorney who's managing your legal and financial matters if you're alive. We have a representative who you may have appointed to manage your healthcare and personal care decisions. Or if you're the beneficiary of a trust, then there's a trustee who's managing money and distributing money to you. So I'm not sure if you meant to say representative, but if you meant to say trustee, you know, if somebody was the trustee for money that they were holding for me, and then I needed help with healthcare and personal care decisions, that person would have no authority because they have authority over the trust. But I would need to have, if we're talking about health and personal care decisions, if that's your question, I would need to have appointed a representative. Otherwise, it would fall back to that TSDM list that Kelsey talked about. I hope that helps. Sometimes it gets confusing because we're talking about so many different types of authorities. Okay, and that's why it helps to have people help you navigate. Sorry, Kelsey, I hope that helps.
It's okay. Thanks, Deborah. Carol has just said, I am the trustee and he has brain damage and no will. So I'm not sure who's going to respond to that.
And trustee of what? If you're the trustee of a trust where the funds are being held for the benefit of a person, you know, you'd be looking first to the trust terms. What do the trust terms say would happen to those funds once that person once that person passes away, which is what you're concerned about at this point, I think, if you're saying they have no will. There would be a question, you know, there would be a you know, legal question there of their capacity to do estate planning and draft a will. So it would depend on the extent of the brain damage. But all of these, you know, there's a whole spectrum of capacity and a specific test for capacity to draft a will. And then there are questions, you know, if somebody has not appointed somebody, you know, if we're concerned about not the healthcare and personal care decisions, it sounds like you're concerned about their estate planning for after death, and they don't have a will. So the first question is, do they have the capacity now to draft a will? And if they don't, then, you know, have an attorney cannot draft a will for them, but what are their alternatives? So I think there you'd be wanting to speak to an estate planning lawyer about what the options would be and the best way to set things up at that stage. Because there are some things that attorneys may have the power to do, or if somebody is appointed by the court to be a committee, if there's no attorney, there are some things they may have the power to do. And then there are some things that, you know, if there's not the capacity to do a will anymore, then the will is no longer an option. But it's a big question and it's very case specific.
Deborah, Carol has just said the lawyer said that he can't do a will due to his brain damage. Is there a form that can help later?
Yeah, let me step in there for that. I've had some experience
Okay.
with people that have passed away without a will, and it isn't an absolute tragedy. There is a process. It can go smoothly. It also can go very wrong. But if there is somebody that either related or that has a personal interest in helping this person that has the brain damage, you can apply through the courts to be the administrator of that person's estate, and you're doing that, applying it without a will. So there's applying for administrator with a will and applying for administrator without a will. And so if the person doesn't have a will and they have somebody that could apply to be the administrator of his estate, going through the probate court, the probate court could then award that person basically the effective role of the trustee of the estate or the executor of the estate. And then that person would have the responsibilities of carrying out those same duties as if a will was written. And so there is a process. There's not a form, there's many forms that would have to be done. So that person would probably want to seek the expertise of a lawyer to guide that paperwork through the courts. That's what they're good at. So all is not lost if something can't be done because of the brain damage.
But if we're talking about somebody who is still alive now, I would go get some legal advice with respect to whether there's any other planning that can be done, because not everything has to pass through a will. So there may be other planning.
Yeah, like naming a beneficiary if possible, things like that.
Carol says, thank you, everybody. This is very good information.
You're welcome.
Yeah. So do we have any other questions that we want to ask our panelists? Anybody who's here as a participant? If you don't have any questions now, but you think of something you want to ask to Deborah or Kelsey or Sean afterwards, please feel free to email us at info@cipo.ca. And we will forward that information over to each one of our panelists so that they can get in touch with you directly and help you with anything that you might have to ask. So on behalf of CIPO, I would like to say thank you so much to our panelists. I always say that you're never too old to learn. And just when you think you know things, you learn more. I learned a lot from everybody today. It got me thinking about, did I do that? Did I do that? So it's good thought. And we are glad that those that came on board got to listen to this great information. And we wish you a wonderful day.
Thank you.
Thank you, everybody.
Have a great day, everyone.
Have a great day. Take care.
Bye-bye.
Bye-bye.